So many thanks for such a clear presentation of such a complicated topic. I think something which is obvious to all of us that, again, it's a quite difficult balancing act with, in particular, if it comes to charging low prices. On the one hand, of course, competition policy should lead to low prices also of dominant firms. On the other hand, margin squeeze, prohibition of margin squeeze, prohibition of predatory pricing, obviously also shall protect the structure of the competitive market as such. I would, although the time is already, I think we're still a little bit in time, but we have some time for questions. I would like to open the floor to questions if there are some. Of course.
Oh dear. Thank you. Thank you very much. Commission bashing was mentioned here, so I felt I had to intervene a little bit. First, I would like to say thank you very much for all three presentations, or four presentations. Very clear, and I agree with 95% of what you're saying. And some of the criticism about the guidance paper. And my question to you, you have to understand the situation that we are in, and the question is, the counter question is, what could we have done instead? We have a situation where, clearly, the old precedents were form-based. If you allow me to engage in a bit of lawyer bashing, they were set by lawyers in the court. They were not based on economic concepts at all. And let's be fair, some of these old judgments include analysis or lack of analysis that are utterly gibberish. I don't remember if it's Control Can or United Brands, but there is this famous phrase where the court goes through the presumptions for dominance, saying that if you're 40%, you're likely to be dominant. If you're over 50, from an economic point of view, that's absolute nonsense. Well, there might be an element of truth in it, but you cannot make presumptions like that. I mean, there's a tendency, but I mean, to use it as some kind of criterion for fine dominance, it's nonsense. So what should we do? As the Commission, we want to go to a more effect-based approach, but we cannot go back and say all these old judgments they were taken by in the old times by lawyers, and so we cannot disregard them. So we want to make a general move, and we try to make these guidelines, which have no legal value. I mean, of course, we stand to be corrected by the court, and that's part of the system. So I would say also, yes, there is a bit of slalom there, but I think that the clear ambition is to move towards the more effects-based system. And it's tricky and it's a bit complicated. So yet again, it's a balancing act. But I think we should move towards, I mean, we have learned a lot from our American colleagues that we should move towards a system of rule of reason. And of course, the downside of a system of rule of reason is that you don't get any clear criteria. Rule of reason is a case-by-case analysis, and that makes your job harder, I understand. But yeah, maybe you should look at it from a positive side. No matter which approach the Commission uses, you can always criticize us from the other side. So if the Commission uses a purely form-based approach, you're saying, hey, look at the guidance paper, we're not taking into account the economic effects. If we do the other way around, you say, hey, look at this precedent and look at this precedent and so on. So I think I understand your frustration, and I also understand that it was a deception, that it was a that you were not very happy with the paper that came out, and the discussion paper was much more ambitious. But you also have to understand that also reflects internal discussions within the European Commission between economists and lawyers.
I think we understand that, and we appreciate that
yes.
As well.
And just one thing I had to say, yes, about your slide with the different landmark cases. I'd like to register a complaint. You missed one case, which I happened to be involved in. That was the Deutsche Post case from 2001. Yes. Okay. That was actually the first case where we seriously started to discuss different cost measures, and in particular ELRIC. And then we have moved on from that. But I think I think somewhere there we started thinking seriously about these things. Thank you.
Agreed. Thank you, Doug. I mean, sincere apologies for the Deutsche Post omission. I think you're absolutely right. The Commission was always in a difficult position, but I think the Commission is more susceptible to accepting false positives than the US is. And because of that, it puts us in a position where a type 1 or type 2 or type error in an assessment is more tolerated in Europe, which is unfortunate. But we have an example of agency where actually there was a departure between the courts, the European courts, on agency, what was the risk that the agent had to take, and the Commission guidelines. And the Commission guidelines were more stringent on that. And yet, on agency, we just followed. There was no debate. The Commission just went ahead, produced it as guidelines, which could be relied upon, as this is the way we're going forward. The problem with the 102 guidelines that we've ended up with, they've been disabused so much and weakened so much that I do not know of what their value is now. Paolo.
No, I mean, I've been involved a considerable amount of time with that guidance. Clearly, I've seen the struggle and the difficulty you were mentioning that the Commission had gone through in the past few years. I would like to say one negative thing and one positive thing. The negative thing is, as we were saying before, because of what's been happening, it's very difficult to use it's certainly guidance for you, but as external lawyer, when we are advising in-house, the value is very, very limited. If I have to say what the merit of that paper is trying to push the courts to have a more effect-based approach, because actually the problem, as you would say correctly, is actually the courts, that whatever you do, they come back with a very formalistic and legalistic approach. And I would say that's the merit, the effort to push them. And it's a mixed, I mean, you put all your efforts, the court is reactive, possibly not as quickly as we would wish.
Well, and another argument for a competition court, a specialised court to deal with these issues, actually.
I'm in between for national courts. They are sometimes in the same position as external lawyers, so for them it's in particular also complicated to move between the guidance paper and the European court and maybe a national practice still existing.
Yeah, can I just, obviously I'm not a lawyer, so I'm not qualified to sort of comment on these sort of legal issues about the role of the court and so on, but that's not going to stop me from doing so. So I just just want to make a couple of comments from sort of personal experience. I mean, the first is that, you know, I have experience when I was at the Office of Fair Trading of trying to draft guidelines, and I recognise the problems that are faced, particularly when you're an economist trying to write guidelines and you are involved in discussions with lawyers who are telling you that you can't actually say any of the things that you want to say. So I fully understand those sort of issues, and I think that the Article 102 priorities paper, I think it's actually an excellent paper, and I think it is, you know, given the constraints, I think it does a very good job of pushing things towards a more effects-based approach. The other experience is that I would like to talk about is my experience on the Tomra case, where I advised Tomra. So Tomra was found to have infringed what was then Article 82 for various issues, one of which was an issue of retroactive rebates. And Tomra appealed this case to what was then the Court of First Instance, although by the time the case came out, it had changed to the General Court. And in the process of that, one of the arguments that Tomra made was that the Commission hadn't followed the approach in its guidance paper. And the Commission, quite rightly, in defending its decision, said, well, our decision predated the guidance paper, so the guidance paper is irrelevant. What we did is we followed the law as it was at that time, and if you follow the law as it was, you know, at that time, you can see that Tomra was infringing the case law of the court. And the court has agreed with the Commission. It said, yes, you're right, your guidance paper is completely irrelevant. Taking a formalistic approach, there was an infringement of the law. But the problem with that case is the Commission, and you know, we tried to point this out to the Commission during the process, the Commission, in defending its decision in Tomra, has almost killed off its own guidance paper, in that there is now a great deal of confusion of people saying, well, following Tomra, the guidance paper is irrelevant. The court has told us the guidance paper is irrelevant. So, I think the Commission can get around that. The Commission can say, well, Tomra predated the guidance paper. If we were doing Tomra now, then obviously we would have regard to the guidance paper and so on. But the problem is that the Commission has never sort of said that. And I think there is a sort of an issue of communication here that the Commission needs really to clarify the situation of the guidance paper, because people look at these cases that are coming out and they see the court overruling the guidance paper, and it leaves people wondering, well, what value does the guidance paper actually have. So I think there is a role for the Commission in basically reasserting the value of the guidance paper and reasserting its commitment to follow the guidance paper going forward. One last point is I think that even having done that, there is going to be a lacuna going forward, which is that if the Commission tries to follow its guidance paper, and as inevitably happens with these things being complex, it may be that the Commission gets it wrong and misapplies its own guidance. The question is, well, who is there to correct that mistake? Because if a company appeals against a decision, an infringement decision, and goes to the court will say guidance paper irrelevant. We're going to follow the case law. So I think at the moment there is, the way that sort of things have worked out, there does seem to be a bit of a lacuna in terms of oversight of the Commission, that however much the Commission might commit itself to follow its guidance paper, there is no one around who can actually hold the Commission to account and make sure that it actually follows the guidance paper and applies it correctly.
Although, of course, it actually follows both. Intel was a classic example of this. It follows the form-based plus the effects-based just to make sure that it doesn't have that problem.
Okay, are there any additional questions or comments? Okay, so many thanks again to the panelists and also to you for your attention, although lunch is waiting.
We were holding them up for lunch.
Sorry, I know.
Boris, when do we have to stay back? At 2:30 or do we have 10 minutes more? So 2:40? Yeah, 2:40. Many thanks.
Yeah, we didn't do bad.
No, we didn't do that.